Hey guys, welcome back to my channel. Welcome to my channel if you're new. I hope you're having a wonderful day as always. My name is Kseniya and I make videos for people who, like myself, are going through the family-based immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers. And the purpose of my channel is to simply help you guys go through this process completely on your own, and also to avoid mistakes, which is what we're going to talk about in today's video. In today's video in particular, I wanted to talk about the form I-130, which is the first step in the entire process of petitioning your relative to come to the United States. And I wanted to pay your attention to a specific part of the form, which is extremely important, if not the most important part in the entire application. And that is the part which asks where the beneficiary will continue to apply for their green card. If you are looking at the paper-filed form I-130, these questions are located on page 8 of the form in part 4, and they are the questions 61A through 62C. And if you are completing the form I-130 online, these questions are located in the Other Information section, the Adjustment of Status subsection. Why is it important to answer these questions correctly? Is that if you do not answer these questions or you answer them wrong, you potentially risk delaying your case by a few more months to even years in some cases, and you also risk having to pay additional fees, and I will explain why later in this video. However, let's just quickly look through the questions first. When you are filling out this application, the petition itself does not grant a visa for your relative. However, USCIS needs to know where exactly the beneficiary or your relative will continue to apply for a green card. If your relative is currently inside the US and is eligible to apply for something known as adjustment of status, also known as the form I-485, in that case, you will answer the first half of these questions, which is questions 61A and 61B. This section says that the beneficiary is in the United States and will apply for adjustment of status. The question is asked in the exactly same way on the online form. So if your relative is currently inside the United States and you're planning to continue the adjustment of status process for them, then in that case, you will simply provide an answer to this question and nothing else. In order to answer this question, you simply have to write the city or town at which you reside and also your state, and then USCIS will respectively choose an appropriate field office which will continue to handle your case. This is most likely the office where you will go to submit your biometrics, and also the office that will continue forward with your green card interview if you have one. Most of the time, you will answer this question if your beneficiary is currently inside the United States, and you will most likely submit an adjustment of status application for them concurrently, such as in the case with immediate relatives of U.S. citizens who are eligible to submit the I-130 petition and then also follow it up with the adjustment of status application. The second half of this particular question refers to people who will be continuing their green card application process overseas at a U.S. embassy or consulate. In that case, you will not be answering the adjustment of status question. You will be moving on to this particular question. So on the paper filed form, it is questions 62A through 62C. You will only answer these questions and you will not answer the adjustment of status questions. Same applies to the online application. You will only answer the bottom half of the questions as you scroll down on the online application. The reason why it is so incredibly important to answer these questions correctly is because if you accidentally do not provide a response to these questions at all, or you, for example, provide an answer that the beneficiary will adjust status in the United States when, in fact, they have to go through a consular route, in that case, you will have to request that USCIS transfers your petition, your approved I-130, to the National Visa Center, and then the National Visa Center will continue to work on this case. Unfortunately, if you have to do that, in that case, you will have to file the form known as I-824, and also you will have to pay an additional fee for that. And the other thing that you should be aware of in terms of the form I-824 is that that particular form, so this process of transferring your approved petition to the NVC, can take between several months to a year, and even a year and a half in some cases. So not only will you be paying an additional fee, you will also be delaying your case. Before you submit the petition for alien relative, you definitely want to make sure that you analyze these questions. And even in the cases where your beneficiary, for example, is currently located in the United States, but you feel like maybe they won't be adjusting status, maybe in fact you will have to continue the process overseas at a consulate. For example, maybe you're filing for your parents, and for medical reasons or other emergency reasons, you foresee that your parents will not be able to actually stay in the United States here and will have to go back home. Then in that case, perhaps it would be easier to continue their process at a consulate or embassy overseas. In some cases, people rely on having their beneficiary apply for adjustment of status, as well as the travel document, which temporarily allows you to leave the United States while your adjustment of status is pending. But you need to keep in mind that the travel document, which is also known as advance parole, takes a very long time to be approved, in a lot of cases 9 months or even longer. You really need to think about where your beneficiary will continue the process, because you really want to avoid having to transfer your petition, pay an additional fee for the I-824, and wait many months before it even reaches the National Visa Center. This is also the kind of question that you want to answer correctly when you're petitioning for any other relative that is not an immediate relative of a U.S. citizen. So if you are, for example, petitioning for your son or daughter who's over the age of 21, or maybe you're petitioning for your siblings, even though they may be visiting you currently inside the United States, they will not be able to adjust their status until their spot in line on the visa bulletin approaches. And in a lot of cases, this wait time for your spot in line on the visa bulletin can take between 5, 8, 15, or in some cases even 20 years. As you might imagine, the beneficiary probably will not be able to stay in the United States without a proper visa for so many years before they're able to adjust status. I would say arguably these questions are the most important questions in the entire application, because they will determine the future of where you will continue to apply for a visa. I hope that you found this video useful. Please let me know if you have any questions. Subscribe to my channel if you haven't already. Obviously, give this video a thumbs up so more people can see it. And I hope to see you guys in my next videos. Bye!